Hello and welcome. Today we're going to be talking about 5 important tips you need to know if you get sued. And I can't say this enough because it needs to be repeated at all times. Getting sued is never, or needing to sue is never enjoyable. Nobody enjoys it. It's very tedious. It's very painful. Both emotionally as well as cost-wise, but unfortunately as business owners, it tends to be a fact of life. It's not a matter of if, but when you get sued. And so these are the tips that are going to help you get through it and help you to accept that reality as opposed to being the entrepreneur that doesn't. If you're new here, my name is Taylor Darcy from Think Legal, where I help you create the business of your dreams. So welcome. I'm happy to have you here. If you haven't liked or subscribed to the channel, don't forget to do that and hit the bell icon. We go live every weekday, Monday through Friday, except for holidays, at 11 a.m. So please stop in. I'm here to answer your questions live. Let's get started. Number one, you want to understand the litigation process because again, it's not a matter of if, but when you get sued. And so knowing what the litigation process is can help calm you down because I know it can freak you out. But there is so many points between when you get sued to anything truly bad happening that I want you to relax and just take a deep breath and recognize that this is what it is. And this video is going to help you get to the point where it's not going to be an issue or not as big of an issue as if you pretend that it won't happen to you. First, the litigation process starts by having a summons and complaint and typically an ADR or alternative dispute resolution packet delivered to you via messenger. And the way that works, it's called personal service. There are other ways that you can be served if you dodge the process server. Just because you choose not to get served by dodging them doesn't mean that it won't happen. So rather than dodging them, the best answer is to go ahead and accept the service of process. The person that gives you the stuff is not a party to the suit, and they have to be over 18. So it won't be the person. You don't have to worry about being the person that's suing you. It's going to be somebody else. Then from there, you begin what's called the pleading stage. And the pleading stage is if you are the plaintiff in the matter, you serve on the other party the summons complaint. If you're the defendant, you accept the summons and complaint. And then that you have 30 days from the day you receive the summons and complaint as a defendant to respond with what's called the answer. And an answer can be many things, but it usually consists of a general denial as well as different affirmative defenses that you would plead or that you argue that even if this is true, even if you're found guilty, here are your affirmative defenses or the defenses that you say don't keep it from being completely true or that there's alternatives to what the facts that they're doing. That's if you are the defendant, if you receive the summons complaint and then you respond with an answer. After that, you begin what's called the discovery phase. The discovery phase is the longest and most tedious and also most boring. And discovery consists of several different options. I won't go into all of them, but just know that first is typically written discovery, where you'll be asked to respond to a series of questions that you'll be asked to respond with documents. You'll be able to ask to respond with requests for admissions, which is just to admit or deny the truth of something. And then from there, you can, both parties ask each other information. That's the process of discovery, and written discovery is the most intense or most commonly began with, because then after you've got your written discovery, the depositions and that type of thing get fed off of that, funnels the questions into the depositions, which is verbal People come in and are sworn under oath to tell or not to tell the truth, to tell the truth, sorry. They swear to tell the truth, and they're deposed under penalty of perjury, just like they are in court. The idea and the whole purpose of a deposition is to get them to admit to facts that are not easy to be admitted to in your written pleadings. It also allows you to follow up questions that you don't have to do, or that you don't have available to you in your written discovery. It's really a powerful tool if done correctly, and also that means you're on the receiving end of things. It can be your subject to a deposition just like the other party is. No, I have to caution you, discovery is fairly expensive. It's very time consuming, and it's very costly because the attorneys are going to charge you to respond to and compile the discovery. So it can be very, very expensive, which is why most cases settle at the discovery phase because of the cost on both parties. That doesn't mean that it always happens. It just means that that's because it starts getting expensive. That's where they start saying, oh, I don't want to pay the money. I'd rather just pay to get out of it rather than deal with the expense of discovery. That's just kind of as an FYI. The next portion of the thing, now this process, unlike the TV shows, can take months, even years, depending on the nature of the litigation, the alleged damages, the willingness of the parties to discuss a settlement. And so it can be quite a while between when you file the complaint and summons on the person to when you actually have a resolution, if you get a resolution at all. Typically, like I said, most cases, 80 to 95% of all cases settle. Only about approximately 5% of all cases that end up in actual court in front of a trial, jury, or a judge. And we'll talk about those in just a second. Then after you've done your discovery, depending on the discovery, you can also you can file motions for motion for summary judgment, which basically says, look, we all agree on the facts, you decide on the law, and let's all go home. And that's a tool that's used to try to keep it out of court. The truth is, the courts don't want to actually hear your case. They want you to solve the problem yourself. They want you to listen to the other party, and their role is meant to be strictly to solve it if the two parties can't. So they'll suggest other means like alternative dispute resolution, which can include mediation, arbitration, so on and so forth. So demand or required settlement conferences, review by a judge that's not involving a trial. After your motion for summary judgment, if you lose on the motion for summary judgment, you can still, which basically says if you lose, that there's a triable issue of fact at that point. And when there's a triable issue of fact, you can go to the jury, or you can have a bench trial, which is just the judge, and they will be the arbiter of not only the jury is the arbiter of fact. If it's a bench trial, the judge is the arbiter of both fact and law. That gives you kind of a little bit of a context. Then if you make it that far, then you have a trial. And the trial is the presentation of the facts to the jury, if you have a jury trial, and to the judge, if it's a bench trial. And at that point, then there's a yes or no, whether or not who wins. From there, depending on who wins, you can, and this is, by the way, just a very high level overview. There's a lot more steps involved. There's a lot more minutia. And so I don't want you to get bogged down in the details of this, but I want you to be aware of the process, that it takes a long time. It can be very expensive, and you want to make sure that you're sure that what you're doing is correct because of that cost that goes with it. And you can lose. So there's no guarantees if you pursue a course of action. Even if you believe you're 100% right, you can still lose because the jury may not view it the same as you do. Once you finish the trial, if you lose, whichever side that you're on, you then can have an appeal, and that gets appealed to the next level court. In California, it goes from superior to the appellate court, and the appellate court reviews for any issues of law They are not triers of fact. No court above the original court is a trier of fact. And this applies throughout the state system as well as the federal system. So once that appeal happens, you apply, you say why this is wrong of the trial if you lose, and the other party may do the same thing, or they just may finally just say, okay, fine, we'll pay it. It's not worth appealing. Depends on the amount, depends on what you're asking, depends on the demands. There's lots of factors that go into it. Again, this is a high-level overview. Once you've won or lost your appeal, that tends to be it. You only get a automatic appeal as a matter of right. One, that's it. You don't get as many bites at the apple as you hope to have. Now, you could appeal to the next court up, but they grant or deny based upon whether they'll hear it if there's an issue of law that was undecided or incorrect at the appellate court level. So it typically ends at the appellate court, whatever appellate court that may be. So you have to keep that in mind, that it can be a years long process. We're not talking short. This can be several years before you receive an absolute judgment. Once you receive the judgment, you can then move to enforcing that judgment through garnishment, levies, till tax, various different ways, liens on property, and all of these ways will allow you to collect on the judgment that you win. Now, this is why I wanted you to be aware of that, because each step of the litigation process is an opportunity to settle, an opportunity to calm down and to let your anger out, frustration, or your defensiveness, and ask yourself, what is your pride worth to you? Because if it's worth it, then sure, by all means, keep fighting. But eventually you could lose. The way that you can be covered is by knowing that this process exists and being prepared for it. In some instances, if you have insurance, they will you tender the claim to the insurance company, and the insurance company will then pay or fight on your behalf. That's a way to be covered, and that's the purpose of insurance. So if you're wondering why you should pay for insurance, especially like liability insurance or E&O insurance, that's why, is to cover you in case of a claim against you. Now, here's the downside to that. There's a couple of things. If you're the plaintiff, insurance companies don't cover. They just don't. They're only on defense. That's all they do is defend. The other thing is insurance companies will only, if they cover the claim, it's great, but sometimes they can deny the claim, and sometimes if it exceeds the policy limits. So if you only have a lawsuit for $100,000 or your insurance policy is for $100,000, but your lawsuit is for $1 million, they may bow out at that $100,000. They'll say, look, we'll pay the $100,000, but we're out. And so then you're still on the hook, or potentially on the hook, for the additional $900,000. Insurance is great, but it's not the catch-all that you want to have. Another way to protect yourself are a couple of ways, and these are brief, and I've talked about these in other videos, so I don't want to go into too much detail, as having good contracts that limit your liability, as well as having a liability shield such as an LLC or corporation or LLP, that type of thing. So those are three very easy, quick, relatively painless ways to protect yourself in case of a lawsuit at those type of things. Probably the best way that you can protect yourself from a lawsuit is to budget for it. What do I mean by that? I mean saving a portion of your income, of your revenue, and putting it in a savings account, setting it aside to cover your legal expenses in case you are sued, so that it's not an emergency thing and you aren't stressed out about coming up with the money in order to pay the lawsuit or pay the attorney to defend you for the lawsuit, or as the plaintiff. Okay, so either way, if somebody doesn't keep their commitment on the contract, you have the money to prosecute. That's probably the best way to make sure you're covered, because that keeps it in your control, as opposed to insurance that it may not be in your control to defend or prosecute and get the settlement that you're looking for. Because again, it comes back to, it's not a matter of if, but when you get sued. So it's always better to just plan on it than it is to assume that it won't happen. Now, eventually, the good news is if you do things right, and you're a good corporate citizen, you have good corporate counsel, and you're proactive, your likeliness of getting sued goes down significantly, because you're doing things right. You're not taking advantage of people. So that money that you're saving from your start can then be used to pay for your legal counsel until you can afford to pay them in a different way. And that's a budgeting question. But the idea being, save for legal expenses. You're going to thank me for it. The next thing is, if you are sued, make sure that you're gathering all of your relevant documents. Keep good documents. Keep good track of what you're trying to do and who it is that communications, especially when you believe that a relationship is about to go south. If someone complains vehemently and they end up filing a complaint, you want to make sure that you've covered yourself, protected yourself, legal documents, paper trail, everything you can to make sure that you have as much backup as you can to provide, not only for the other side because it can weaken their case, but also to protect yourself in case it does go to trial. Next thing and last thing that you want to do is make sure you're hiring an attorney that aligns with your values as a business owner. And I see this happen quite frequently, mostly in family law, but this can happen in business, is you hire a pit bull attorney and it ends up costing you more money than what it's worth to you because they go after every nit and every detail and they just try to pound the other side. And the problem with that is that, and this is where that whole what is your pride worth to you perspective comes in, is that pit bull attorneys tend to also be more expensive because they spend a lot more time fighting for you. Now, if that's what you want, absolutely. If that's your pit bull mentality, if that's, if you're another Martha Stewart, then by all means, but be prepared for that to cost you more money. If you're more of a que sera, sera sort of person, or you're like, hey, I just want to get out of this, I don't want to deal with this anymore, then you need to find somebody that has a similar temperament to you because then it will cost you less money, typically. It isn't that don't just think, is this person good, but does it fit with your values of who you are as a person? If you want a pit bull and are willing to spend the money, be the pit bull, find the pit bull. Awesome. Do your thing. But if you're more of a, hey, I just want to settle this for the least amount of money as possible, I don't care about my pride, I want to get the attorney that will settle this and that I'm protected against future lawsuits, then find that attorney. And that's a good way to get referrals from other attorneys, from friends, from just overall, it's a good way to find somebody who's that type of an attorney. There is no one size fits all. Not every attorney is perfect for your matter. And that it goes without saying is there are attorneys that do litigation, business transactions, family law, some that do a mix of everything. So you don't want to necessarily hire a personal injury attorney to do a business attorney's litigation. It just we look at contracts differently. We look at litigation differently when it comes to that. If it's a slip and fall, there's medical records, there's expert opinions, there's so many different things. So keep that in mind, that you want to make sure that you're finding the right specialty, and then within that, personality-wise, that person's special. That bulldog or peacemaker, whichever side you're looking for. If you've gotten value out of this video, please don't forget to hit subscribe and like. And remember, when we go live at 11 a.m. Monday through Friday, except for holidays. Have a great one.